Good evening, and thank you for joining us for this evening's webinar on unpacking your estate plan when moving to North Carolina. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Ward & Smith, and I'll be moderating today's presentation. Before I introduce our presenters, I would like to take a moment just to handle some housekeeping items. We are going to utilize a few PowerPoint slides during this webinar, and we think it will be helpful for you to be able to see both the video speed and the slides at the same time. To do this, you may need to make one adjustment to your view settings. Find the View Options button at the top or bottom of your screen and click on it to see your options. Then choose the side-by-side mode. The slide deck should appear on the left and the video feed should appear on the right. You can then slide the separator to the left or right to adjust the size of each view. If you have any issues with video or sound quality during the webinar, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. We also will try to answer as many questions live as we are able to during the webinar. If you have a question, please type it into the Q&A box and I'll do my best to incorporate all of our questions into the discussion as time allows. We do have two presenters tonight. Tom Zimatics, as you will see, has joined us, and Eldridge Dodson is having some technical difficulties, but she'll be able to log on momentarily. I will take a moment to introduce both of our presenters, and I'm going to start with Tom. So Tom works closely with individuals, families, and closely held business owners to provide personal plans to help them identify and achieve their unique estate planning goals. His practice focuses on estate planning and estate and trust administration. He assists clients in the preparation of a wide range of estate planning documents, including wills, trusts, and powers of attorney. And we'll flip over here to Eldridge. So Eldridge, who will be logging on soon, is certified by the North Carolina State Bar as a board certified specialist in estate planning and probate law. She assists all types of clients in drafting and implementing estate plans, including estate, gift, and generation skipping transfer tax planning. Eldridge also provides counsel to executors and trustees in administering estates and trusts. Tom, I'll go ahead and turn everything over to you and we can begin the presentation.
Great, thank you, Jen. And thank you everyone for joining us this evening. I are very excited to present on the topic tonight, and we hope that you find it useful and informative. And really, I think there's at least two takeaways that we hope you get from the presentation. The first is, in the scenarios that we're going to present, we're going to talk about many different estate plan documents that should be a part of any basic estate plan. So if you're coming to the presentation and your only question is whether or not your will from your previous state is valid under North Carolina law, while that's a good question, please pay attention to some of the other documents that we talk about, like a power of attorney, revocable trust, and really the purpose of the presentation is not only how to update your will to meet the standards of a new state, namely North Carolina, but also how to make sure that you have a comprehensive estate plan in place when you move to a new state. And then secondly, the other takeaway that we hope you get from the presentation is that relocation to a new state, especially North Carolina, is not uncommon. Maybe a generation ago, the big move for a family would be from Goldsboro to Raleigh. Today, it's Raleigh to New York, Raleigh to Atlanta, and then back again. I would say probably most families have siblings or children who are spread across various states in the United States. So movement is increasing, and we think that relocating to a new state is one of those life events that should call to your attention your estate plan. When you move to a new state, there's increased risk that your current documents may miss, and bringing those up to date with current law and applicable law is important to mitigate any risk when you move to a new state. And even if you don't have anything in place, just like when you have a child or you retire, there's certain life events that make you think that now's a good time to update your estate plan. Moving to a new state is one of those. There's a lot of considerations to make, especially with who to choose for fiduciary designations. So there's a lot in play, whether you're personally moving to a new state or you know someone who is, or you work with someone who is. We think that updating your estate plan when you do so is important. So those are the takeaways we hope you get from the presentation, along with some other information. So with that, I see Eldridge is on. We're going to talk through some scenarios tonight that we think represent some of the most common problems people may face when they relocate to a new state in regards to their estate plan. So we're going to talk through some scenarios now.
Okay, great. And Eldridge, is your audio working now? Oh, I think we might still be having some problems. Let me get through this. I'll read the first scenario and Tom can start talking, and then I'll try and troubleshoot with you. Okay, so scenario one this evening is Sam and Jenna are a retired couple in their early 70s. They were both married previously and have children from their prior marriages. Sam has 2 children and Jenna has 1. They each have wills that they had prepared right after they got married 20 years ago. Sam was recently diagnosed with the early stages of Alzheimer's. To have more family support, they have decided to move from New York to North Carolina to be closer to Jenna's daughter and her family. And Tom, would you like to take the lead on that one?
Yes, let's talk about Sam and Jenna. So I think this scenario is one where estate planning probably would come to mind for the couple, especially with Sam's diagnosis of Alzheimer's. Certainly, Sam and Jenna will be coming to North Carolina with the idea that they need to institute long-term care planning for Sam. But that's not the only issue that Sam and Jenna should consider when they move here to North Carolina. When I talked about in the introduction that you want to make sure you have a comprehensive estate plan, one of the most important documents that you have in place is power of attorney. And so with that, we're talking about durable power of attorney and healthcare power of attorney. A lot of institutions are familiar with in-state documents. They seem to process faster and without issue. For example, if you need to go to a financial institution as the attorney in fact, present the power of attorney. In our experience, presenting in-state documents that conform specifically to North Carolina statute generally are processed easier than out-of-state documents. So one of the first things that Sam and Jenna should do when they come to North Carolina and they meet with an estate planning attorney is talk about updating their collateral documents, powers of attorney, under North Carolina law. And what that will do is allow Sam and Jenna to appoint an attorney of fact who could represent them and their interests in regards to a lot of matters. Financial decisions under the durable power of attorney, managing their property. And the key about a durable power of attorney is that it's durable in that it lasts through and is effective through the principal's incapacity. And so for Sam here, it's important that he has durable power in place, whether it's Jenna or one of the children who would serve as attorney in fact, that you have those documents brought forward with them in North Carolina. In terms of the will, they definitely want to at least review it with the attorney. Under North Carolina law, if a will was drafted pursuant to the previous state's execution laws and was valid in that state, it will be valid in North Carolina. That being said, 20 years have gone by for Sam and Jenna. They're moving closer to one child. It's more of a complicated family setup with children from previous marriages as well. And so it's important to talk about their goals, distribution at death, and who would receive the property, make sure that their distribution goals are aligned with what they were 20 years ago. So that's another consideration. In terms of the long-term care planning, that would take place whether they moved to North Carolina or not, given Sam's condition. But this is, and we'll touch on this in future scenarios in this presentation, this is where having the team of advisors is really important. Sam and Jenna should be going to an attorney who can not only help them with updating their estate plan documents, but can also help with long-term care planning, with Medicaid, meeting with financial advisors to make sure that they have a plan in place to allow Sam and Jenna to take care of Sam in his illness, but then also set Jenna up for success years down the road. So those are some of the scenarios that, or situations you want to think through for Sam and Jenna.
Thank you so much, Tom. Eldridge, do you have sound now? Let's see. Give it just a second.
How about now?
There we go. Great. Thank you so much.
Okay.
All right.
Thank you. Okay. Thank you all. So I had trouble hearing Tom, but some of the things that also couples like this who are in second marriage want to do is, and basically they want to have a good plan, because if Sam was incapacitated, they want to pick the right person to help him while he is incapacitated if Jenna dies first, or even if Jenna's alive, to make sure he's got the right person to help him. In addition, they want to make sure, since he might become incapacitated, that he's involved in planning now for disposition of assets at the second death with a second marriage. So I think his looming incapacity adds some extra things that the couple should make sure they thought through, as well as the second marriage issues lead to some things that they should think through carefully. But Tom raised the point that I think is particularly important in this case about the collateral, is that he has something in place right now, because he may lose the chance to update them later. So he needs to have someone named and a backup, and he also needs to think through very carefully who he trusts to do the best job to care for him if he no longer can make his own decisions.
Thank you, Eldridge. Should we move to scenario 2? Okay. So for scenario 2, we have Paige. Paige is a single woman in her mid-60s. After a successful career as an environmental lobbyist in DC, she's decided to retire and move to the coast of North Carolina. In preparation for her retirement and her move, Paige had the attorney who handled the sale of her condo prepare a revocable trust and update her estate planning documents.
Okay, so I think here in scenario 2, updating your estate plan during this move may not be as an obvious consideration for Paige as it was for Sam and Jenna before. Based on the facts, Paige has done everything right. She's had a successful career. She made the smart decision to move to the coast of North Carolina for retirement. She even had the attorney who handled the sale of her condo set up the revocable trust. So Paige is doing a lot of the right things. It's still important for her to double check everything. And let me first start with the revocable trust plan. If you are moving to North Carolina and all you know is a will, and that's what you're familiar with, a revocable trust can also achieve distribution of property at your death. It works somewhat differently, where you would create a revocable trust during your lifetime. You would serve as trustee, and then the key to a revocable trust is that you would title your property and your assets under the trust. So then at death, the successor trustee would then become trustee and then manage the property that's titled under the trust and distribute it in accordance with trust terms. And so for someone who's moving to a new state, Paige here, a revocable trust plan could be very useful. It's not always the case for everyone, but there are certain advantages to a revocable trust that I think would work for Paige here. Take, for example, if she maintained some real property, say in upstate Virginia. Maybe she still has friends and she wants to visit and she loves the area, but she just wants to be in North Carolina along the coast for most of the year. If she has real property titled in her name in a different state, and she has property in North Carolina, or she's domiciled in North Carolina at her death, it's quite possible that Paige is going to have probate proceedings, which would manage the distribution of her estate through the probate court and then to the heirs. She could have probate proceedings in multiple different states, and that's where the revocable trust could be very useful. If Paige is able to title all of her assets under the revocable trust during her lifetime, it could make the management of her trust property at her death much more convenient for the trustee and for her loved ones. I think another added benefit here for Paige, who's a single woman in her mid-60s with the revocable trust, is you also get some incapacity planning. It's quite possible that Paige is moving to North Carolina just because she loves the beach, and she may not have family close by or close friends yet in the area. And an added benefit to a revocable trust is that Paige would set up a successor trustee who would manage her property when she would become incapacitated. And so it's an extra benefit to the revocable trust that a will-based plan may not cover. All that being said, again, I think I mentioned it in the scenario, first scenario, having the team of advisors. Someone in Paige's position, the bulk of her assets may be in an IRA. And so she may be able to set up a revocable trust or just have a will-based plan and think that she has all of her assets distributed at death in accordance with the terms of her trust or will. Well, if all of her assets are in the IRA is going to pass pursuant to the terms of the plan. And if it's been a number of years since she's updated the beneficiary designation of an IRA, or even if it's been recent and there's new legislation like the Secure Act, it's time to revisit that so that she can make sure that who's designated under the IRA to receive it is who she wants, and it's aligned with her overall estate plan. So again, I think it's great that she went ahead and had some documents executed, but when you get to your new state, you want to make sure that you have the comprehensive plan in place and you don't miss anything. And then in terms of, if Paige had old documents, she brought them with her to North Carolina, and she just wanted to make sure that they're up to date and valid. You could still reach out to an attorney, have that review, and it may be the case that the plan works. The will is valid and you don't need to draft new documents. We do that at Ward & Smith. We can do that review for you. Even if it doesn't involve creating a new estate plan, it's still good to check in with it when you move to a new state.
Okay, thank you, Tom. So scenario 3 this evening is Adam and Virginia. They have been married for almost 50 years. They're both native Texans and have lived outside of Houston their entire lives. Virginia was recently diagnosed with a heart condition, and their daughter has insisted they move closer to her. They leave the Lone Star State and move into a cabin just outside of Asheville.
So there are additional considerations for someone who's moved from a community property state that we want to be careful with when they move to North Carolina, and it's really tax driven in that case. Individuals who live in a community property state enjoy a benefit that the rest of us do not have, which is you can reduce dramatically the income taxes, the capital gains for a surviving spouse, because at the first spouse's death, all the community property assets get a new basis. So if, for instance, Adam died and Virginia survived, all of their community property assets would get a new basis as of Adam's death. And if Virginia then later sold something, she would have minimal capital gains. In working with clients who've moved here from community property states, we've done several things to preserve their community property status. There are several options to do that, but it's in many cases a huge tax benefit to the surviving spouse. So it's something you need to be extra careful about when you do move from one of the 8 community property states to any common law state, such as North Carolina. And we would do the North Carolina planning when we've worked with community property spouses who've moved here. We've done the North Carolina planning, plus we've done some planning to make sure we preserve the basis at the first death, getting the full step up.
Tom, did you have anything to add to scenario 3, or should we move on to the scenario 4?
That was the real benefit or the distinction of adding this scenario, is to make sure that anyone who's moved from one of the 8 community property states, make sure they don't lose that benefit.
Yeah, I think we can move to scenario 4.
Thank you, Eldridge. Okay, so scenario 4 is Crystal and Matt are in their 30s and just got married. Shortly after they got married, Matt is offered an HR position at SAS in Cary. Although they have no family in North Carolina, they decide to leave Pennsylvania and settle into life in North Carolina. They currently have no estate planning documents.
Okay, so scenario 4, Crystal and Matt, I think they're very interesting because in their 30s, no children yet, busy lives, getting new jobs, moving across states. I am sure estate planning is not at the top of their list. But again, let's walk through some of the risks, especially in moving to a new state where, if they have other financial goals like saving for a new home or building up savings with the new job, that estate planning should be something that they think about too. And the first thing that comes to mind is for Crystal and Matt is, in the event the unexpected happens and Matt or Crystal were to die, what would happen to their estate or their assets with no estate planning documents whatsoever? As most of you probably have heard, there's intestacy, and that's not unique to North Carolina. The same thing would happen in Pennsylvania. But each state has their own intestacy laws, and when someone dies without a will, their assets will pass pursuant to the law, the intestate law of the state in which they live at their death. So in this case, if they've settled in North Carolina intestate law will apply to Matt's death, for example. And if Matt has significant assets in his name, he may be surprised at what North Carolina law would provide. If he's married, you may think that everything will go to Crystal, and that may not be the case. Take, for example, if Matt has significant assets in personal property over $100,000. Well, up to that $100,000, everything will go to Crystal. But everything above $100,000 under intestate laws in North Carolina, because Matt has no children, he has a surviving spouse, and he has surviving parents, well then half of everything over $100,000 will go to the surviving spouse and half will go to the parents. And if Matt has significant assets, that may not be what he wants to happen if he has an untimely death. And then with real property too, let's say they are not married when they move to North Carolina. They buy a house before they're married and they purchase it, they own it, tenants in common, and then they get married and they never retitle the house. For real property, again, for someone who's survived by a spouse and parents, half of the interest in real property will go to the parent and the other half will go to the surviving spouse. So that would create a situation where Matt has an untimely death, they have a house together, now his parents have an interest. That's probably not what Matt wanted to have happen. And so even though they are leading busy lives, starting new jobs, just getting a simple plan in place to direct his assets or her assets at their death is important. Another issue that I think they should consider is fiduciary designations. And again, the comprehensive estate plan. If Matt were to become incapacitated, he would want to have a plan in place at the ready so that there's no confusion between his parents and his spouse on who's making the decisions, whether it be healthcare or just managing the finances. So again, getting the durable power of attorney, healthcare power of attorney in place is very important so that Matt would be taken care of in the way that he would want. And another document that would be very important is an advance directive. So if Matt was on life support or had life-preserving measures in place, he could state his wishes directly in that document or provide that the healthcare power of attorney control that decision. These are all things that they're probably not thinking about, but just having the basics in place could prevent confusion and heartbreak between the family, and also set the surviving spouse up for being in the best position despite the circumstances to continue to move forward. And then the last thing to talk about in this scenario, to bring it back to the whole family, let's say Crystal is an only child, her parents are still in Pennsylvania, and they've recently completed their estate plan documents and they've named Crystal throughout to always be the fiduciary or the executor. It's important for parents to keep in mind too, as their children move away, what that would do to their estate plan. And it may be the case that they're fine with a child serving in an important position who lives maybe far away, but it's just something to think about in terms of the importance of who's making decisions for you, who's managing your estate, and where they are, and are they able to do that. So that's one thing. It's not just individual to Crystal and Matt. I think whenever you have a family member move across state lines or far away, you want to make sure that you review your own estate plan, make sure that you have everyone in place in the right position.
Great. Thank you so much, Tom. So that concludes our scenarios for the evening. We did, however, get a question from the audience. And so, Aldridge, I'd like to direct this question to you. And the question is, have you looked into using a charitable remainder unitrust as the beneficiary of an IRA to receive similar stretch IRA treatments?
Well, the Secure Act that was passed in December has changed all the rules for retirement accounts. But naming charities as the beneficiary of an IRA definitely gives you an income tax benefit. So for someone who has charitable inclinations, having a charity as a beneficiary is the most tax efficient way to pass funds to charity as opposed to the rest of the family. So making a charity as a beneficiary. We have not used charitable remainder trust since the passage of the Secure Act. The rules are not 100% sure yet as to how that will work, but it may turn out as we get some more guidance from the IRS to be an option worth exploring.
Thank you so much, Aldridge, and thank you to our audience member for asking that. It was a really good question. So that concludes this evening's seminar. Thank you so much to Aldridge and Tom for taking the time to speak on these issues this evening. For those in attendance, following the webinar, I'll be sending an email with a list of articles related to the issues we discussed today, information about Ward & Smith's Essentials package, and a link to sign up for our Ward & Smith Trust and Estates client alerts. We also will make a recording of the webinar available. We so appreciate you taking the time out of your evening to join us. Thank you again, and this concludes the webinar.